Welcome to The Explainer. If you're studying for the Queensland bar, you know that getting expert evidence right can literally make or break your case. So, what do you do when you need an expert but proceedings are already underway? Well, today we're breaking down the 3 critical pathways under the UCPR that you absolutely have to know for your exam. Okay, let's set the scene. Imagine you're deep in a really complex case, maybe a commercial dispute or a personal injury matter. Suddenly, a huge issue pops up that just screams for an expert opinion. How in the world do you get that evidence before the court? Well, the Uniform Civil Procedure Rules, or UCPR, give us a roadmap, but you've got to know how to read it. So, here's what we're going to cover. First, we'll look at the overall roadmap. Then, we'll dive into each of the 3 pathways for appointing an expert one by one. And to finish, we'll lock in the key strategic takeaways you need to have in your back pocket for exam day and for your life at the bar.
All right, everything we're talking about today, everything, revolves around one central rule, Rule 429G of the UCPR. For your exam, you need to think of Rule 429G as the main signpost. It points you down 3 different roads you can take to appoint an expert after a proceeding has started.
You'll see Rule 429G is split into 3 parts, each one creating a totally separate pathway. Subrule 1 is all about appointing an expert by agreement. Subrule 2 is what you do when you can't agree and you have to apply to the court. And Subrule 3, well, that's when the court just decides to do it on its own. Let's dig into each one.
Let's kick things off with the first, and let's be honest, the most collaborative option. This is Pathway 1, found in Rule 429G, Subrule 1. This is the joint agreement route, and it's the one the courts really want you to take. Now, on the surface, Rule 429G1 sounds pretty simple, right? You and the other side agree an expert would be useful, so you just appoint one together. It's efficient, and it helps avoid that whole battle of the experts thing. But, and for your exam this is a huge but, it is not as simple as a handshake. Not even close. See, this agreement pathway has some serious procedural teeth, and they're all laid out in Rule 429H. Look at this checklist. It's incredibly strict. You have to agree in writing on the exact issue, the expert's name, the timeline, and the costs. The expert has to agree to it all, and then you have to actually file that signed agreement with the court. If you miss even one of these steps under Rule 429H, the whole appointment could be invalid. So what happens when that kind of collaboration just isn't in the cards? Maybe the other side is being difficult, they won't agree on an expert, or you can't even agree on the question to ask. Well, that leads us straight into our second pathway, making an application to the court under Rule 429G, Subrule 2. Yep, Rule 429G2 is your go-to procedural tool when negotiations completely fall apart. It lets any one party go to the court and say, hey, we need help here. Can you appoint an expert for us? This takes the decision out of the party's hands and puts it squarely in the courts. Now, if you're going to make one of these applications, you have to follow Rule 429I precisely. First, you've got to serve your application on everybody else. You have to put forward at least 3 qualified experts who have already agreed to act. You also have a duty to tell the court about any connection between your proposed experts and the parties. And here's the real kicker. After all that work, the court is not bound by your list. They can pick someone else entirely. And this is the million-dollar question. It's one that actually divided judges for years, which makes it a perfect exam topic. Does Rule 429G mean you have to use one of these 3 pathways, or can you still do it the old-fashioned way? Just go out, hire your own expert, and call them at trial, as long as you follow the other disclosure rules. So on one side of this debate, you had judges like Justice McMeekin in a case called Stewart v. Felberg. He basically said that the whole point of these rules was to control how expert evidence gets in. His view is that if you just ignore Rule 429G and hire your own person, you're taking a huge risk that the court might just refuse to even hear their evidence. But then, on the complete other side, you had Justice Freiberg. He argued really strongly that parties have a fundamental right to call their own witnesses. He pointed out that Rule 429G says a party may apply, not that they must. So, in his mind, the rule gives you an option, but it doesn't take away your basic right to build your case with the experts you want. So, who was right? This debate was messy, and it needed a clear answer. Thankfully, we got one from the Queensland Court of Appeal in 2019. The case you absolutely, positively have to remember is Thompson v. Tremco. And the Court of Appeal's answer could not have been clearer.
They said the idea that Rule 429G is the only way to get expert evidence in was, and this is a direct quote, wholly misconceived. This is the critical point. Rule 429G is an option. It is not a command. You can still hire your own expert as long as you play by the other rules on disclosure.
Okay, that brings us to our third and final pathway, which is laid out in Rule 429G, Subrule 3. This is what happens when the court doesn't wait for the parties to act, but instead decides to step in itself.
That's right. Under Rule 429G3, at any point in the case, a judge can just look at the issues and decide, you know what, an expert report would be really helpful here. And then they just go ahead and appoint one. The specific procedure the court has to follow for this is set out in Rule 429J. Now, this pathway is a real double-edged sword. On the one hand, a court-appointed expert is seen as impartial, and it can save a ton of time and money. But the downsides are significant. There's a risk the judge looks like they're getting too involved, entering the arena, so to speak. And there's a huge practical problem, which came up in a case called Frick. You lose that direct access. You can't just pick up the phone and call the court's expert for a quick chat like you could with your own. And the court doesn't make these decisions lightly. When it's thinking about appointing an expert, either because you've applied under Pathway 2 or on its own under Pathway 3, it has to follow a checklist. That checklist is in Rule 42K. The court has to weigh things like how complex the issue is, what the impact on costs will be, whether it'll speed things up or slow things down, and of course the overarching interests of justice.
Phew. Okay, we have covered a lot of ground. So let's boil it all down. What are the absolute must-know points that you need to have locked and loaded for your exam and, just as importantly, for your career?
First things first, Rule 429G is your roadmap. Know its 3 subrules. 429G1 is agreement, and that's governed by the very strict procedure in Rule 429H. 429G2 is your application when you disagree, governed by 429I, and 429G3 is the court's own initiative under 429J. And please, burn the case of Thompson v. Tremco into your memory. These pathways are options. They are permissive. They are not mandatory.
And we'll leave you with a final thought to chew on. Knowing these rules isn't just about ticking procedural boxes. It's about high-level strategy. So in your next case, when you think about an expert, is pushing for a single joint expert a weak move that limits your options? Or is it a brilliant strategic play to control the evidence/costs and frame the entire debate on your terms? The answer? Well, that depends on the case. Good luck with the exams.